Is there something people are not aware of when it comes to wrongful death claims? Attorney Ben Glen explains. Back in 1988, a California Supreme Court decision was made in the case of Murati Shalal versus Fireman's Fund Insurance Companies, 1988. Unbelievably, that case removed the wrongdoer's insurance company's duty to act in good faith towards the victims of the wrongdoer, and further removed the burden and the duty of the wrongdoer's insurance company to make a prompt and reasonable good faith settlement. Up until that case, under the California Insurance Code, it was the duty of the wrongdoer's insurance company to make a reasonable and prompt settlement in all cases when an insurance company insured a wrongdoer. The newly reconstituted Supreme Court, whose justices were then, in part, appointed by then-Governor Wilson, became a court with a majority of justices much more favorable to the concerns of the insurance companies rather than the needs and concerns of claimants and wrongful death victims or injury victims. So that court reinterpreted the Insurance Code of California and decided that duties of good faith, fair dealing, and providing a prompt and reasonable settlement applies only in cases when the claimant is making a claim against his or her own insurance company, when that claimant has a contractual relationship with his or her insurance company. This occurs in relatively rare matters, such as where there is an uninsured motorist and the claimant has to make a claim against his or her own insurance company, as there is no insurance to pursue on the part of the wrongdoer. The outcome of this decision has been more than tragic to all injury victims, and in these wrongful death cases, the surviving family members or other claimants of the wrongful death descendant. One hopes that the legislature will one day change the law in this regard and return the burden of acting in good faith to the wrongdoer's insurance company. Therefore, wrongful death claimants are left with having to deal with insurance companies that feel free to essentially tell victims to take a flying leap. These wrongdoers' insurance companies use different tactics when dealing with claimants directly. They may try to falsely act sweet and say to the wrongful death claimant, for example, "Oh yes, you know we understand your tragic situation, so take $50,000 and you should realize this is great compensation for you. God bless you, and have a great day." When the case may be worth $500,000, $1 million, $5 million, $10 million or more. And then there is a great deal of insurance coverage beyond the $50,000 offer. This is the job of these insurance companies and the representatives, to save the company money, as much money as possible, and to absolutely pay as little as possible to claimants. They tried to settle the wrongful death case very early on for some small amount of money, and oftentimes the wrongful death claimant does not realize how big a case he or she really has. Other insurance companies' representatives come off making the claimant feel as though there is an obligation on the claimant's part to give the insurance company information when there is no such duty, and try to intimidate the claimant. For a free phone consultation, contact Attorney Ben Glen in California at 877-236-4536 or visit www.gleninjurylaw.com.